Very good evening, everyone. Today I'll speak specifically about Brexit, European law, and as the Brexit is knocking in our door, 31st of December. Specifically, I'll address today about the parents, as a parents besides the family members, because I have noticed recently many applications for EU family permits or EU pre-settled status leave to enter is refusing by the Home Office on the ground that the EU nationals fail to provide evidence of dependency. Now, what is the legal position? Because family members means under the regulation 7 as well as under the EU settlement scheme, close family member means your children under 21 years old. If over 21 over 21, they have to provide dependency. Your spouse or civil partner, as well as the regulation 7 and EU settlement scheme says dependent parents. However, does the applicant responsible need to provide evidence of dependency, or if the Home Office refuse the application for EU family permit on the ground that they are not satisfied that your parents is dependent on you? What the law said actually, what the legal position is, whether EU regulation or EU settlement scheme. And I think many applicants or EU nationals, they are not familiar with this law. Now, although Regulation 7 or EU settlement scheme said that the dependent parents, but the applicant or EU nationals doesn't require to prove that the parents is dependent. That's what the law is, because law assume that the parents are dependent on EU nationals. That's what the legal position is. Accordingly, those applicants, those EU family permit or family permit for the parents who refused by the Home Office, this is unlawful, because if you look at the policy guidelines for EU settlement scheme, if you click on dependent parents on that link, you will see the explanation that very briefly, only within short 2 lines, that this policy actually written by the Home Office in the policy guidelines, that parents doesn't require evidence of dependency. Law assume that parent is or parents are dependent on their EU nationals. Therefore, if the Home Office refuse your parent visa, parents family permit application on the ground that parents are not dependent or they are not satisfied, this refusal is unlawful. You should make an appeal to the faster tribunal and tell the court, print a policy guidelines, the page where it said that parent doesn't require provide evidence, because if the law said parent doesn't require evidence of a dependency, that is your money receipt or bank statements or required health care or any assistance look after, you don't need. If the law clearly said that you don't need to provide evidence, in such case the refusal of EU family permit by the Home Office is unlawful, because the second line, it said that law assume that parents are dependent, and it clearly said the parent doesn't require provide evidence, although we advise that provide some evidence, but law doesn't require. Now, if the Home Office refused your application for EU family permit, this is unlawful, and you should appeal to the upper tribunal, and you need to address correctly the law to the faster immigration tribunal. Now, EU settlement scheme again introduced pre-settled status for leave to enter. And again, if the Home Office refuse on the ground that your parents is not dependent on you, you can appeal it, print a copy of policy guidelines, give it to the judge, and tell the page number that on that page that is said that parent doesn't require to provide evidence of dependency. The law assume that parents is dependent. Now, I have recently attended a case or in telephone hearing, and exactly same things I told the judge. The Home Secretary, her own policy said that parents doesn't require to provide evidence. Parents are law assume that they are dependent. Therefore, the anti-clearance officer refusal of parent family permit is unlawful, unreasonable. Accordingly, the Home Office representative have no answer because it's conflict. Their decision is conflict with their own policy guidelines. So if you need any help about it, if you need any representation, you can contact with our team. We are happy to help you. So this is the one issues what I want to address, because I'll not speak about point-based system. I'll not speak about the immigration new policy or a student visa. I'll speak only for EU law today. Second one, Brexit is 31st of December. Now, many people doing one important mistake. I think I'm not sure why they're not think about it. Today, I see two of my clients. They applied for permanent residence card. Unfortunately, they were not advised, so I told them you make the wrong application. And not only them, many people are doing the same mistake. Accordingly, I thought that I'll address this on a live session, that the EU nationals and the EU family member, you shouldn't make an application for EU residence permit or EU permanent residence card. You should make an application for EU settled status or pre-settled status, because after 31st of December, EU residence permit or EU permanent residence permit will be no more valid. So you should make the application. And another thing, I think probably those who already get the decision from the Home Office, you know it, because Home Office are issuing EU family permit or permanent residence card visa only for 6 months, 7 months, 8 months, 9 months, like that. Why? The question is why they are not, because normally you should get visa for 5 years, but they are issuing visa for 8-9 months. The reason is they are issuing visa up to June 2021. So whoever make the application for under the EU law, they are getting visa for 8-9 months. So therefore, what the correct approach? You should make an application under the EU settlement scheme. If you make an application under EU settlement scheme, you will get visa for 5 years, or you will get settled status for 10 years. So when you make the application, make under the EU settlement scheme. If you apply for EU family permit, again for your parents or for your brother, sister, or for any family members, make pre-settled status for leave to enter. So because under EU settlement scheme, you can make an application from inside the UK or outside the UK. If you live from inside the UK, you should make pre-settled status for leave to remain. If you make the application from outside the UK, you should make the application leave to pre-settled status for leave to enter. Now, another issue people are facing about when they make the application, especially for non-EU family member, when they make application for paper-based application, I mean for leave to enter, pre-settled status for leave to enter, or family permit under EU settlement scheme, when they go to the main application form, they find two questions: family member of EEA nationals or close family member of EU nationals. Which option you should choose? Okay, close family member means, so because you are not familiar with the definition of close family member, because this is many professional even they are not familiar with these terms, because close family member defined by the EU settlement scheme, and the family member is defined by the EU regulation 7. So that's why people are confused. So you should make an application for close family member if they are your son, they are your parents, they are your partner, civil partner, or they are your spouse. Another also issue: can someone apply as a partner? Because civil partner, I hope you understand, when same-sex partner, they're married, then they're civil partner. But what about the normal general partner? For example, someone not married, they are not spouse, because if you want to be a spouse, you have to marry. So those, for example, someone had a relationship with someone over in Bangladesh, now she or he want to invite him to come there. They are not married. You cannot invite as a spouse because you are not married. You cannot invite as a civil partner because you are not in a relationship of same-sex relationship. So what the option in that case? Yes, if you can apply, still you can apply for as a durable partner. So if your relationship is longer, more than 2 years, then you can apply for your partner to come to the UK. You can apply for your fiancé to come to the UK as a durable partner. You need to provide evidence that you had a durable relationship with the non-EU nationals. What is durable relationships? Is a question of fact that you must be keen to marriage, and your relationship must be longer than more than 2 years. So you can provide evidence, you can provide proof that your relationship was more than 2 years, you were keen to marriage, then you can apply as a durable partner. Now, when you make the application for close family members for overseas application, especially when you apply for your parents to come to the UK as a EU family members. Now, deadline is 31st of December for Brexit. Now, the many people from Europe, especially some of my relatives and friends, also client contacted with me, is the 31st December is the deadline. I have a family. My son hasn't finished the school. My daughter will finish the job on after January. So what we can do in that situation? If any family want to come from the Europe, 31st December is the deadline to come to the UK. However, if the situation is like that, you not able to come to the UK before 31st December because your son school or college or they have an exam or some other family commitment for which you will not able to travel to the UK before 31st December. What option available? You should come to the UK, make an application for pre-settled status. You can go back there and then finish your tax job or whatever it is, and then you can come back to the UK again. One option. But remember, if you left UK more than 6 months, and if you live in Europe anywhere, in that case, your leave to pre-settled status will be revoked by law, according to law. Maybe Home Office will ask you when you apply for settled status, provide evidence that you are no longer you are not absent to the UK more than 6 months. So this will be an issue. But if you come back before 6 months, then your pre-settled status will not be revoked. In terms of settled status, again, if you left UK and lived anywhere else more than 2 years, your settled status means your indefinite leave to remain will be revoked by operation of law. So this is some issue what EU nationals and their family member must be aware, because I notice many people are coming to the UK, make the application for pre-settled status, and that I have now UK visa, so after 31st December I can come back. So they left UK, leaving, go to Germany or Spain or somewhere else, living there, that I have no headache, I have pre-settled status, anytime I can return back to UK. This is not the case. So you should transfer your life in the UK, but you can, if you go for holidays for 4 months, 5 months, less than 6 months, that will be not an issue. So this is the one option I said, that you can come, make the application, get pre-settled status, and go back to Europe before 6 months. You can come back. Another option is, for example, you have a family, mother, daughter, children, or about 5-6 months. Now, all of you are EU nationals or some non-EU nationals as well. One option you still have, that you can come after Brexit. This is a very technical, you have to understand. Under the free movement law, as well as under EU settlement scheme, the family member, for example, at least one family member who is the main person of the family. For example, the father can come to the UK before Brexit. He start work, apply for pre-settled status, and after 31st December, he can invite his dependent family members, so son, wife, children, or anyone who is dependent on him. He can bring his family after 31st December. So at least the main family member should come to the UK before 31st December, and after 31st December, he can invite his family member to come to the UK. So at least you can protect the both. You can come to the, someone will come to the UK, he will start work, he will gain pre-settled status, and then you, mother, or the other family member can do their task, what their commitment, what they left to do in the UK after this 1st of December. And once you've done everything, finish college or school in June, July, then you make a decision, okay, we'll go now because the main family member is in the UK, so father will sponsor for the children to come to the UK as a close family member, and then all of you can come after 31st of December 2020. But what you have to prove that time when you want to come, that you are the family member, you have a genuine relationship with your with the father, so you need to provide evidence like a birth certificate, passport, utility bills. If he's sending money, this is the evidence what you can provide and establish your relationship. This is how technically you can come after 31st December 2020. But at least one person, the main person who you are dependent, he has to move to the UK. I hope you understand what I'm trying to make you understand. Another important issue is the deadline for application for pre-settle or settle status is not 31st of December. 31st December is the deadline for Brexit transitional period will end. However, EU nationals and their non-EU family member can make the application even after 31st of December to till June 2021. So if anyone come before 31st of December 2020, they are in the UK under the EU law and they are within the limit. So what the heck can do if anyone cannot make the application before 31st of December, or they cannot make the appointment, or some other reason they cannot do make the correct application to the Home Office, they can make the application after 31st of December, even up to June 2021. So this is the other issue. The deadline for application is June 31st December, June 2021. Another deadline for family member, EU national who will be in the UK before 31st of December 2021, they can invite their family member to come to the UK up to 31st December 2025. So you family members, they can come up to another 5 years under EU settlement scheme. For example, Mr. Chaudhry, he is in the UK 31st of December. Now he didn't bring his family. So what are the options for him? He can make the application even after 31st of December 2020. He can make the application after June 2021. He can make application until December 2025. But he need to satisfy, he will be required to satisfy some requirement, 3 conditions. First, his relationship with non-EU family members or EU family member, whatever, his relationship with that family member has started before 31st December 2020. So if the child born before 31st December 2020, he can come under EU settlement scheme and under the EU law. His relationship was continued after Brexit and was still a subsisting relationship, was continue the relationship until he make the application. So, for example, if someone married before 31st December 2020, for some reason he cannot bring his wife in the UK, he can make the application after 31st December 2020, because his relationship has started before 31st of December. So you need to provide evidence of your relationship. That is, marriage certificate will be a date which is the date is with before 31st December 2020, and then his relationship was continue. You make an application in 2023. So the wife will get leave to enter for pre-settled status, for leave to enter, and this is what the condition is, that relationship started before 31st December. The person who came in the UK was a qualified person, hold the pre-settled or settled status. Relationship was continue until the day of application. If you satisfy all these requirements, you can invite your family member after Brexit, after 31st of December, to till another further 5 years. So this was all about my today update. So I'll advise you, many family from Europe, they want to come to the UK, but for some other commitment, they are not able to travel to the UK before 31st of December 2020. For you guys, my advice is at least send the main family member to the UK, make the application for pre-settled status. So the main family member in UK, you are the dependent, you can come after 31st December 2020. Second option is make the application before 31st of December 2020 and then come after 31st of December 2020. Third option is travel to the UK before 31st of December, make the application now, get the pre-settled status, then go back to the Europe, done your work, do all the commitment, and come back to the Europe before at least before 6 months. Because if you receive the pre-settled status and if you spend more than 6 months anywhere outside the UK, your pre-settled status will be revoked by operation of law. Same as settled status, if you travel somewhere and if you stay outside the UK more than 2 years, your settled status will be revoked. So those who hold the pre-settled status and settled status, you have to be bear in mind that you cannot stay outside the UK for pre-settled status for more than 6 months and for settled status for more than 2 years. Some people, because this rule actually imported from the exported from the immigration rules, because this is applicable for domestic immigration rules, which is applicable for non-EU nationals. If anyone got ILR and if he spent for outside the UK for more than 2 years, then he need to apply for returning residence visa application, and because his ILR sometime by operation of immigration rules 18 is revoked. The same law introduced in settlement, EU law settlement status. The last advice, not advice, this is information, because my whole live session in Facebook is information only, it's not a legal advice. So last information, those who mistakenly making application for EU residence permit or EU permanent residence card, you are getting short-term visa for 8-9 months. Now for you should make an application immediately for settle or pre-settle status, because you set a permanent residence card or the residence card will be no more valid after Brexit. So you should make an application immediately after once you receive your pre-settled status. But if you don't get your decision before 31st December, don't wait for the decision for residence permit or permanent residency. Straight away make an application for pre-settled status. Otherwise, you will be fall in outside the transitional period and may face more trouble later. So this is all about today. If this information is helpful, because my live session today is only dedicated to my EU nationals, brothers and sisters. If it is helpful, please feel free to share in your page for the benefit of the community. Many people still they are not making the application. Today I said two client I met and they didn't know about it. They hold a permanent residence card and then don't know about that they need to apply for settle or pre-settle status, because they believe permanent residence means permanent. They don't need to apply. But permanent residence is not permanent. Permanent residence is, it will be expired 31st December, will be temporary. So this permanent residence is, I will not tell it's a permanent residence. Permanent residence is now temporary residence. 31st of December, the permanent residence will invalid after 31st of December. And if you want to live permanently in the UK, you should make an application under the EU settlement scheme for settled status. Now, after 31st of December, if you don't have pre-settled status or settled status, and if you don't make the application until June 2021, according to law will presume, or law will, by operation of law, EU nationals or non-EU nationals who didn't make the application under EU settlement scheme or pre-settled status or settled status, you will be overstayed. You will not get public fund, you will not get universal credit or any kinds of benefit. Employer will not offer you job. NHS will refuse to give you treatment. The landlord will not rent a house to you. So life will be very difficult if you don't have pre-settled or settled status. Accordingly, my request, all of you, please apply for settled or pre-settled status, those who hasn't applied yet. If any of your family member or if your extended family member want to come to the UK, do it before Brexit, do it before 31st of December. It's still a lot of time, although appointments are not available. in some country, because in BFS and TLS, some African country, because for Asia and Middle East, BFS provides services, and for Africa, TLS provides services, and it is very difficult now to get an appointment with them, because last minute everyone is jumping to bring mother, to bring father, to bring brother, extended family member, and because of the virus, and also is lockdown, is very difficult to get appointment. But still, as soon as you put your application in the portal before 31st of December, you are safe. You can get an appointment after January or February, it's no problem. As soon as the application is in portal, you are safe. Your family member can come to the UK. So this will bring me end of my today live session. Thank you, everyone. Enjoy your evening, and share this video to your timeline, because I hope this video is very informative. Good night, everyone.